channel the discussion, an objective and impartial view of the issues of interest to you. Nation Beat is on now.
Good morning and welcome to you viewers across St. Lucia and the Eastern Caribbean. My name is Kate Wilson and we welcome you to Nation Beat. Today we are having a conversation on the recently rendered advisory opinion from the International Court of Justice on the obligations of states regarding climate change. And to have this conversation with me in studio are two very competent gentlemen in the persons of our CARICOM climate envoy, Dr. James Fletcher, and elected representative of the public to the Escazú Agreement, Mr. Bishnu Tulsi. Gentlemen, welcome to the program.
Thank you. Thanks.
So first of all, before we delve into the substantive issues that we want to discuss here today, let us find out a little more about our guests here today. So Dr. Fletcher, I know that you now serve as the CARICOM Climate Envoy, but prior to that, from 2011 through to 2016, you served as Minister with responsibility for the public service, sustainable development, information and broadcasting, and energy. So tell us a little more about yourself. I also understand that you created the Department of Sustainable Development. Why was it important to develop such a department?
Okay, well, thank you, Kate, and good morning, everyone. I guess the credit for creating the Department of Sustainable Development, Energy, Science and Technology has to go to then Prime Minister, the Honorable Dr. Kenny Anthony, who had actually signaled his intention to create that ministry in the manifesto of the St. Lucia Labour Party that preceded the 2011 general election. I guess Dr. Anthony's rationale for that was seeing what was happening on the international stage with the increased focus on sustainability, sustainable development, that he felt it was necessary to create that ministry and to combine with it energy, science and technology. And the interesting thing about that ministry is that it also comprise water. The water sector was in there. The whole question of forestry was also in there. So it was really a proper natural resource management ministry. And I was very, very pleased and honored when the Prime Minister asked me whether I would agree to lead that ministry. And again, like I said, it really was a focus on ensuring sustainability as part of our development program. You're right. I mean, currently I serve as CARICOM's climate envoy. I also wear a couple of other hats. I am a REN21 global energy champion, renewable energy champion for the Caribbean. REN21 is an organization that really comprises over 120 different NGOs, and its focus is on accelerating the transition to renewable energy. And what they've done is started off something called the Renewable Energy Champions Initiative, where they are selecting 2 energy champions from every region to really serve as mentors for ministers to help guide them along that pathway. So they've chosen the 2 for Latin America and the Caribbean. One is Ramon Mendez, who's the former Energy Secretary of Uruguay, and I'm the other one chosen for the Caribbean. And I guess the third hat that I wear is the expert non-state actor council member for the Global Green Growth Institute that is chaired by Ban Ki-moon. So yes, I have many fingers in the whole environment, sustainability, energy pot, and I'm very pleased to be here discussing this very groundbreaking advisory opinion today.
Indeed, thank you very much. And we will come back to your role as climate envoy. But Mr. Tulsi, you currently serve as the elected representative for the public for the Escazú Agreement, which is the regional agreement. But before that, you served as in the Department of Sustainable Development of the government of St. Lucia as the Chief Sustainable and Environmental Officer. You also served for many years as the Executive Director of the St. Lucia National Trust. So tell us a little more about yourself.
Okay, thanks, Kate, and good morning, viewers and listeners. Well, I'm originally from Guyana, so I started my professional career as a teacher, science teacher, mathematics and physics. Came to St. Lucia, went to the worked at the Castries Comprehensive School, where I served as the vice principal for 9 years. And then at the invitation of the then PS of of the Ministry of Planning, there was an energy, science and technology unit within that ministry, asked if I could leave teaching and join that. So I joined that in 1990. By 1995, I became the head. Well, then it transitioned to sustainable development.
Yes.
It was first from energy, science and technology to environment, energy, science and technology. And that followed the Rio meeting. Yeah. And then when the first set of sustainable development goals, I think they were called the Millennium Development Goals, came out, that's when Dr. Anthony transitioned to sustainable development. So I served there for 10, 11 years. And at the end, towards the end of, as I was approaching retirement, it was actually Dr. Anthony who I was encouraged to go to the St. Lucia National Trust, which I did. I have since retired from there, and I am still involved in environmental matters. As you mentioned, I am the elected representative of the public representing the Caribbean. The Escazú Agreement is really about protecting the rights of persons who protect the environment. Environmental defenders, they're called. And it's based on 3 principles, the agreement: access to information, access to justice, and public participation in decision making. And the structure of the Escazú Agreement has 6 persons, 2 from the Caribbean, 2 from Central America, and 2 from Latin America, who were selected through an election process to be the voice of the public at the conference of the parties.
Right.
And that's very unique because this is a formal arrangement where the public sits with the state parties during the negotiations.
Wonderful.
Yeah.
So thank you. We have 2 gentlemen who are well placed to discuss this advisory opinion. So just before we go into the subsummary, let me just give you a bit of a background to this whole advisory opinion process. So in 2019, a group of 8 law students from the Imalas campus of the University of South Pacific in Vanuatu, which is in the Pacific Ocean, they were fighting to preserve their very existence. They realized that sea level rise was posing an existential threat to their livelihoods, and so they were looking for a legal avenue to advocate for increased action and ambition regarding GHG greenhouse gas emissions, as well as to ensure that we limited the temperature range to 1.5 degrees centigrade, which is what the Intergovernmental Panel on Climate Change has said is essential for our existence. So they started a campaign, and they thought that they must take that campaign to the highest court of the United Nations, which is the International Court of Justice. But to do so, they needed the support and backing of a United Nations member state. So they lobbied the government, which is Vanuatu, and Vanuatu in turn got the support from the other Pacific islands, which had the similar concerns, and so they began this, this thing was broadened. So what happened was that this campaign took a global turn when the permanent mission, the Vanuatu UN permanent mission to the United Nations based in New York, decided to co-opt a core group of states to draft a resolution to go to the United Nations General Assembly so that it can reach the International Court of Justice. And our CARICOM twin state of Antigua and Barbuda was part of that core state, and that is very, very good. So by September of 2022, informal consultations on that draft resolution started. But by November of that year, it was placed before the wider UN membership for consideration. And so by December of 2022, a text was already formulated, and after 3 informal rounds of negotiations from December 2022 to 2023 in February, a final draft resolution was uploaded to the UN delegate portal for co-sponsorship by the members of the United Nations. So by the beginning of March 2023, it had gathered 105 co-sponsors, Okay, by the time it was put to a United Nations General Assembly vote, it had 145 sponsors, and part of those, and some of the Caribbean countries that co-sponsored was St. Lucia, St. Vincent and the Grenadines, St. Kitts and Nevis, Barbados, the Bahamas, Belize, Guyana, Jamaica, Trinidad and Tobago. Dominica and Grenada, as well as Haiti, they joined the process much later in the game. Okay, but by the end of March 2023, the United Nations adopted by consensus Resolution 77/276, which posed the fundamental question to the court. And what was the court? What was that question, sorry? That question stated, having regard to the Charter of the United Nations, the International Covenant on Civil and Political Rights, the International Convention on Economic, Social and Cultural Rights, the United Nations Framework Convention on Climate Change, the Paris Agreement, the United Nations Convention on the Law of the Sea, the duty of due diligence, the rights recognized in the Universal Declaration of Human Rights, the principle of prevention of significant harm to the environment, and the duty to protect and preserve the marine environment. One, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? And B, what are the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to, one, states in particular, small island developing states, which due to their geographical circumstances and level of development are injured or specifically affected by or are particularly vulnerable to the adverse effects of climate change. And finally, peoples and individuals of present and future generations affected by the effects of climate change. Okay, so that was the question. And of course, written submissions were filed with the court in March and April of 2024. 91 written statements were filed with the court, the highest ever in advisory opinions before this court. And we had 61 written comments. Okay, but from December 2nd right up to the 12th of 2024, 96 member states made oral presentations before the court, and we had 11 international organizations, and of course you know St. Lucia had a delegation before the court. So after months of anticipation and speculation, finally the court on July 23rd gave its advisory opinion. So Dr. Fletcher, I am now going to turn to you. Many have hailed this advisory opinion as a landmark opinion. What, in your view, do you consider are the main highlights of that opinion? And do you think that the court did justice to the question that was put before it?
Well, to answer that question, I'll actually go back to 2015 when we were negotiating the Paris Agreement and trying to get loss and damage included in the Paris Agreement as a separate element. Prior to that, the developed countries had insisted that loss and damage was an extension of adaptation, and there was really no such thing as loss and damage. But small island developing states, particularly those in the Caribbean and the Pacific, had been saying for quite some time that there are some impacts of climate change to which you cannot adapt. They're beyond adaptation. So if you lose your coastline as a result of sea level rise, there's no adaptation to that. You can't adapt to that because you're losing. And in the case of some countries in the Pacific and even some of the islands in the Bahamas, that will disappear completely by the end of this century if things continue. So countries like Kiribati and Marshall Islands will disappear. How do you adapt to that? You can't adapt to that. How do you adapt to the loss of your fisheries because the oceans are now being forced to absorb more carbon dioxide and they're becoming more acidic? There's no adaptation to that. So how do you adapt to a hurricane like Hurricane Maria that goes through Dominica and causes damage that is equivalent to 226% of that country's GDP? There's no adaptation to that. So loss and damage, we felt, had to be a separate element in the Paris Agreement. But the developed countries were mortified because they saw loss and damage as opening a door to liability and compensation. The claims for stating that countries are liable and claims for compensation. To the extent where to get Article 8 in the Paris Agreement, which speaks specifically to to loss and damage, there is a paragraph in the COP decision, because every conference of the parties has a set of decisions that it comes up with. And that COP21 had a COP decision, paragraph 51, which read, Article 8 of the agreement, which is the article referring to loss and damage, does not involve or provide a basis for any liability or compensation. So the developed countries took comfort in that. But we always said, okay, that's fine to put it in the Paris Agreement, but we know we have recourse in international law for liability and compensation. So what this advisory opinion does, together with the Inter-American Court's advisory opinion and the advisory opinion that came from the Tribunal on the Law of the Sea, was really confirm what we had always said, that there is liability that must attach to countries that do harm to other countries as a result of their emissions of greenhouse gases and not taking steps to reduce those emissions. And there is compensation that must be due to the victims of those damages. And that is what, so that's the first thing that the advisory opinion does.
Yes.
The other thing it does is basically says that there are legal obligations on the international law. Very importantly for us, because this has been under threat in the negotiations of late, is a recognition of the special vulnerability and circumstances of small island developing states.
Yes.
Because there are many other countries within the UNFCCC, United Nations Framework Convention on Climate Change, who have been challenging why are SIDS specially vulnerable, that we are equally vulnerable. And we've been saying, yeah, we're not saying you're not vulnerable, but SIDS, because of their geography, because of their landmass, because of where they're located, they are specially vulnerable. And this advisory opinion states very clearly that SIDS are uniquely vulnerable because of the geography and development status. It also elevates the whole question of due diligence, that countries have a due diligence requirement, developed countries have a due diligence requirement to really, and I'm sure this is something we'll speak about, but reflect the highest possible ambition in their actions. It makes a very clear linkage between climate change and human rights, which the Inter-American Court decision also does. It recognizes intergenerational equity, which is very important, because it means now that future generations also have an anchor in this. It's not just us, but it's our children and our grandchildren, because we are making the planet, we are making their community, we're making their environment worse than the ones that we live in correctly. And it also very clearly clarified state responsibility for climate harm, that you are legally responsible for the harm that is being caused, and it's a transboundary responsibility. So it's not just what you do within your boundary, but if what you're doing in a developed country is impacting a developing country, then you have that responsibility. And I think the final thing it did was it affirmed what the International Tribunal on the Law of the Sea had said, that greenhouse gas emissions constitute marine pollution. So when greenhouse gas emissions cause a warming of our oceans or cause ocean acidification, that qualifies as marine pollution. So I think taken together, that advisory opinion by the ICJ has to be looked at as a landmark decision, because it really now allows us to build a whole body of jurisprudence on that decision, that you can now, you can't say, well, there really is no legal basis for us to mount a claim against someone else. I think this does for climate advocates what the decision in the 1990s did in the tobacco industry, where the tobacco industry was saying that cigarette smoking doesn't cause harm. I think this does the same thing. It gives us that legal standing.
Wonderful, wonderful. I think we're due for a break, but when we come back, Mr. Tulsi, we will be talking to you about what it means for our civil society. You're listening to a conversation.
The most important part of the Escazú Agreement is implementation. This calls for government to ensure that the Escazú Agreement has legal status and is the law of the land.
There needs to be legal provisions that if information is requested and not provided, that the person requesting the information has recourse.
So that persons who, especially environmental defenders, persons who defend and who are advocates for the environment, can come before the court and say, listen, this project is creating a nuisance, it is causing environmental harm, not only to the citizenry, but to the environment. What can we do about it before it gets too late? And if perchance, and we hope that doesn't happen, environmental harm has occurred, how we can redress that. Welcome back to the program. Before we went to the break, we were having a conversation on the advisory opinion from the International Court of Justice, which speaks to the obligations of states as regards climate change. And in studio with me, we have our CARICOM climate envoy, Dr. James Fletcher, and elected representative of the public, Mr. Tulsi, for the Escazú Agreement, Mr. Tulsi. So, Mr. Tulsi, we just heard about the highlights of this advisory opinion, and we know that this whole campaign, as I said earlier, began with students, and it was fueled by civil society. And you heard about the questions spoke to present and future generations. What do you think that this advisory opinion means for civil society?
Thanks, Kate. Well, first, like you said, this was started by civil society.
Yes.
And it mushroomed into a decision from the International Court of Justice. Mm-hmm. I think the first thing it speaks to is the power of civil society.
Absolutely.
That once there is a cause that is grounded in science and in conscience, and civil society can get together, they could move mountains. Mm-hmm. Perhaps more importantly, it should also demonstrate to governments mm-hmm. that civil society is a partner and could be a very powerful partner in that regard.
Absolutely.
If, for example, based on this decision, St. Lucia decides to take a country to court for damages caused by a climate-related event. Mm-hmm. Based on the decision, that claim will be made against a larger country, mm-hmm. perhaps a friend, mm-hmm. perhaps someone you rely on for aid. Mm-hmm. And how does that litigation then affect the bigger relationship?
Yes.
That's where civil society can come in. Mm-hmm. Civil society can take the lead in that litigation and shield the state from that political and diplomatic challenge it will face. So we've got to look at the decision in the context in which it was born mm-hmm. and the implications moving forward. And the role that civil society played and can continue to play in being the intermediary body
yes.
that can take action while protecting status quo.
Okay, and we will develop that further in the discussion. So let's get back to Dr. Fletcher. The court was very clear in terms of the obligations under the climate regime, and one of the things that it spoke to was adaptation. And we know that you were part of the negotiations for the Paris Agreement and the UNFCCC, and you are very much familiar with our adaptation plans and our SASAPs and so. Now we know that the states, developed states, which are usually the major emitters, are required to provide technological support, capacity building, and financial assistance to us in developing our adaptation plans. What do you think? Do you think that they are going to provide the kind of support we need, or do you think that this advisory opinion is just wishful thinking?
Well, I think left on its own, the advisory opinion is wishful thinking. If we do nothing with it, if we just have it there as though this was a great win for civil society and for these 135 countries that came together to present this to the UN, then it is wishful thinking. But the onus is now on us as the countries that are impacted and the countries in whose favor this ruling has come down to make sure that this does not remain as just an opinion, but that it now is now reflected in negotiations. So the negotiations coming up in Belém, in Brazil, COP30, that this finds its way on the agenda. Now, agenda setting at a COP is a very technical, very difficult process, but we have to ensure that this finds its way there. We have to ensure that this finds its way in the negotiations, so that when we don't just reference the scientific reports of the Intergovernmental Panel on Climate Change, because climate change, the good thing about climate change is that it is based on science, it's based on empirical data. It's not based on, boy, I used to be able to dive in that river before and I can't dive in that river anymore. That's climate change because there's no water there anymore. It is based on stream flows that will show you that as a result of climate change, that river is not the river it used to be 15, 20 years ago. and you attribute that, how much of that is attributed to climate change. So we now have another arm that we can lean on, and that's the legal arm. It's not just the scientific arm, but it's also the legal arm. Right. Because it says now that these countries are legally obligated. It's not something that they will do if they feel like doing it. They must do it.
Absolutely.
And providing financial support, as you spoke of, the means of implementation, is not charity, it's an obligation, because you are the one who caused the problem, and the courts are saying that you can be held liable. Yes. So we now have to ensure that legal anchor that we have reflects in our negotiations and ensures that the developed countries, the countries that are as you said, historically responsible for the greenhouse gas emissions that we've seen, but also under the United Nations Framework Convention on Climate Change, the Annex II countries, the ones that now have a responsibility under the convention to provide support, means of implementation, so technological support, capacity building, and financial assistance, that they must do it. So, for example, the Fund for Responding to Loss and Damage, which right now is capitalized only to the tune of $250 million. That's it. All of the data have shown that you need $400 billion annually to respond to loss and damage. So the current capitalization of $250 million is not even a drop in the bucket. It's nothing. Yes. But so this now gives us an anchor to say you have to capitalize that fund. Right. You know, you have to capitalize the Green Climate Fund, because how else can the countries that are being impacted by your actions, historical and current, how else would they be able to respond? But the other thing you have to do is to reflect the highest possible ambition in your NDCs, your nationally determined contributions, so that you do the best you can, the most you can, in the shortest possible time to reduce your emissions of greenhouse gases, so this problem does not become compounded and worse over a period of time.
Now, Mr. Tulsi, Dr. Fletcher spoke about the science, and we know how important science is for, for our policies, for our legislation. One of the things that we found, and the court spoke, and the court hailed the IPCC reports, that is the Intergovernmental Panel on Climate Change, the reports as the best available science. Now, we spoke, St. Lucia's delegation spoke to our Caribbean scientists, but we found that during the pre-write shops, where we were learning how to write our submissions, that there is a dire need for attribution science. Okay, what do you think? How do you think we can improve that situation? And not only just attribution science, but science from our Caribbean scientists.
Yeah, thanks. Firstly, when you look at the opinion, the court was comfortable that there is enough scientific basis on which to attribute different countries' contributions to the greenhouse effect. They're happy that there is enough science. The question that they had really was, what's the starting point? Is it pre-industrial? Is it 1980? Is it this when the UNFCCC was finalized? So that science exists, but the central concern, I think, is to what extent we in the Caribbean are applying science to the decisions that we're taking. And I believe that that's where we need to go back to our universities. We need to go back to our research institutions and begin to build science and evidence gathering and interpretation of data and converting it into information, making that available to policymakers and the public. I believe that is where we need to focus. I can't speak with any confidence as to how much of that is already happening. But based on my involvement in the field, I know enough is not happening.
What about data from indigenous persons, from our traditional knowledge and that sort of thing? Do you think that should also be part of our reports?
Well, let me put it differently. The old folks, our grandfather and the great-grandparents, they knew how to work the land in a sustainable way. We have introduced technology, modern methods, and we have superimposed climate change on that. And a lot of those traditional knowledge is being lost. And I think that there should be a concerted effort to do the research to capture that. And in fact, St. Lucia is in the process of developing a cultural heritage policy, which speaks to that.
Absolutely.
Capturing traditional knowledge and how problems were solved in the past and the extent to which they could be applied today.
Okay.
So,
And just to continue on what Vishnu is saying, both Vishnu and I are scientists, so we recognize the value of science. But a lot of science is based on studies that are then peer-reviewed and published in a journal, peer-reviewed by 3 or 4 people. What Vishnu is speaking about with the traditional and indigenous knowledge is information that is as a result of observation over generations and centuries. So you cannot tell me that that is discounted, its value is not as good, or if not even better than what is published in a journal.
Absolutely.
You know, this is our parents, our grandparents, our great-grandparents noticing something over a period of time and saying, and getting that observation validated over many, many years. We had flooding in St. Lucia 2 or 3 years ago in the north, in
Correct.
2 major communities, Grand Riviere, Riviere Meter. Why were these 2 areas called Grand Riviere and Riviere Meter? Grand Riviere, big river. Riviere Meter, the middle of the river.
That's
These were
right.
floodplains.
Yes.
We have now, again, using technology, retrained rivers and built in areas, but water takes its course of path of least resistance. So if you build in a floodplain, Grand Riviere, if you build in the middle of a river, Riviere Meter, expect flooding.
Yeah.
Our foreparents know why they gave those areas those names. But we, in our little bit of our arrogance, you know, of modern science, think that we can get nature to behave in a different way. So that's why the indigenous and traditional knowledge is so important.
Very, very important. So speaking about rivers, and let's segue now into the sea, because the court also outlined obligations under the United Nations Convention on the Law of the Sea, UNCLOS, and it spoke specifically to sea level rise as regards maritime baselines and maritime boundaries. So my question to you, Dr. Fletcher, is it spoke specifically to the fact that if sections of a state or an island, say St. Lucia, get submerged, that does not necessarily mean that they would lose their statehood. Now, given the importance of self-determination to countries to islands like ours, what do you think about those pronunciations?
That is such an important ruling by the ICJ, because it means that your exclusive economic zone, your EEZ, is not impacted by sea level rise. So as you've pointed out, even if the sea encroaches as a result of climate change, and maybe your coastline that used to start by where the new hotel, the one that used to be Wyndham Morgan Bay, can't remember the new name now, where it starts, and if the projections show that maybe with a 2 degrees Celsius warming, that coastline might move inland closer to where Massey Mega is, it does not mean that our exclusive economic zone is any smaller, because the island ends at a particular point. And that's of even greater significance to some of the islands, as I said earlier, in the Pacific. Islands like Kiribati,
Yes.
Tuvalu, Marshall Islands,
Yes.
that will probably disappear, because these countries are atolls. They you know, the highest point is maybe 1 meter above sea level.
Absolutely.
So it does not take much, a couple of giant tides or sea level rise of 1 meter, 1.5 meters, as is projected for the end of the century, to see the complete disappearance of those islands. However, those islands, even if they have disappeared or they have shrunk, their sovereignty remains, their status as an island remains, their exclusive economic zone remains, and it's not that some other country will now be able to claim that space as its own. So that's why that ruling is so
wonderful.
important.
Now, Mr. Tulsi, you know, with climate change comes displacement and migration, especially with sea level rise, and it can create climate refugees. So one of the things that the court spoke about is this duty, or this principle of the non-refoulement principle, where courts, not courts, but where member states are expected not to expel or return persons who are displaced by climate-related activity to countries where they will face harm. Okay, what do you think about this pronouncement by the court, and how do you think that we can develop safe, and non-discriminatory pathways for climate displaced persons?
Well, climate displacement is already happening. There are places around the world where, because of climate-related events, people are being forced to move, and move permanently in some cases. The challenge there in addressing the question you asked me is, where is safe? And to where do you move people so that they are not You're not taking them from a bad situation to one that is perfect.
Worse.
Climate will affect mountains. Climate will affect every nook and cranny of the planet. So the solution to me has to be one of mutual respect. That's the first thing. And we've got to look at the solutions in terms of what do you do with displaced persons.
I see.
Not in the context of the persons only, but look ahead, look at the intergenerational perspectives.
Yes.
And it all keeps coming back to mitigation and adaptation. That is the perfect solution. It's not finding the safest place, because some places will be safer than others, but they're all vulnerable.
Okay.
Okay? The solution has to be in the long-term mitigation and adaptation.
International cooperation again.
Yeah.
Good faith international cooperation.
And coastal erosion will happen. The sea level will rise. There is no doubt about that right now in the science. Very little doubt, I should say. Yeah, and so coastal communities will be affected. Abandon and retreat is a concept in adaptation, because there are certain things, like Dr. Fletcher said earlier, you cannot adapt to. So all of these factors have to be built into future development, and how you find the best solutions to relocate displaced persons.
Okay.
It's not a single answer. It's a, you've got to put the whole package
compendium
together.
of things.
Yeah.
Yes. Okay. Wonderful. Now, Dr. Fletcher, I know that you've been a champion for the energy sector. You've been when you were in government, and also through your consulting firm, Solaricon, you continue to look for ways towards that just transition towards clean energy sources. One of the themes permeating this advisory opinion was, what do we do with fossil fuels? We're talking about the subsidies and so on, and so important was it that two of the judges Bihandari and Cleveland, they had separate opinions on what should be done in terms of the fossil fuels, how to deal with fossil fuels. At the present moment, there is a call, so to speak, asking for an open-ended working group. Do you think that the time has come to establish such an open-ended group to kickstart, so to speak, negotiations towards a treaty on the proliferation of fossil fuels?
Yeah, that's such a great question, Kate. Some information. Fossil fuels are being subsidized to the tune of almost $7 trillion.
Right.
The IMF, not Greenpeace, not Oxfam, not some environmental organization, calculated that fossil fuels are being subsidized to the tune of $13 million a minute.
Wow.
So that is why fossil fuels continue to proliferate. That is why fossil fuels continue to look more attractive than renewable energy, even though solar power plus battery energy storage systems right now is outperforming every fossil fuel except maybe natural gas, and in a couple of years it will outperform it. So yes, and I know the last few COPs, they have tried to put in language about the phase out of fossil fuels, even something that should not be controversial, like the phase out of coal, and that has been met with fierce opposition by some of the coal producing countries and the major fossil fuel countries. The time has come for this. Now, I know this will bring, this is joy to the ears of some of the people who are working on, there's already a movement for a fossil fuel non-proliferation treaty. I know 17 countries, including 3 from the Caribbean, Antigua and Barbuda, St. Kitts and Nevis, and the Bahamas, have actually joined up to this fossil fuel non-proliferation treaty initiative. And I know I have some Caribbean colleagues who are working on this, people like Gillian Cooper and Una May Gordon, who have been really pushing this. So yes, I think the short answer to your question is this is something that has to be pursued. It will be met with fierce opposition, particularly from the major oil-producing countries. When we were negotiating Paris, one of the delegates from an oil-producing country came to me and waved his finger in my face and said, "You small island states will get lost and will get 1.5 over my dead body."
Wow.
We got 1.5 and he's still alive, so that's a good thing. But it tells you the level of opposition you will get to this. But it's important. It's important.
So we're due for a break anytime from now, and when we come back, Mr. Tusi, we will look at the right to a clean, safe and healthy environment. So you're listening to a conversation on the advisory opinion with respect to the obligations of states on climate change, and this advisory opinion was rendered by the International Court of Justice on the 23rd of July 2025, this year in particular.
Quality information is needed to make the decisions that will ensure St. Lucia's natural resources are used wisely and sustainably for generations to come.
Without information, people are likely to make the wrong decisions, and people are not likely to know what is happening around them and how they could protect themselves.
Welcome back to the program. I have with me in studio Dr. Fletcher, James Fletcher, the CARICOM Climate Envoy, and Mr. Bishnu Tulsi, elected representative for the public of the Escazú Agreement. He represents the Caribbean and Latin America. And we are having a conversation on the advisory opinion from the International Court of Justice, which speaks to the obligations of states regarding climate change. So, Mr. Tulsi, let's turn again to you. One of the themes permeating not just the advisory opinion of the International Court of Justice, but also that of the Inter-American Court of Human Rights before it, is the right to a clean, healthy, and sustainable environment. Not just for our present generation, but for future generations. It speaks to intergenerational equity. Okay, so as a representative of the Escazú Agreement, which is a wonderful tool to ensure that we attain, the goals that we want to see in terms of climate, action. How can you use the Escazú Agreement to implement this advisory opinion?
If we step back a little first before I get to the direct question. Every international agreement, the UN Charter, the constitution of every country, there's one common element. It is the protection, the right to life.
Yes.
And we have done so much harm to the environment that pollution now is a threat to that very fundamental right that all countries promise in their constitution to people of those states. So at the very core, the right to a healthy environment has been translated or is being translated as a threat to life if the healthy environment is not assured. Absolutely. In the context of the Escazú Agreement, it came about from the Rio Declaration, Principle 10, where it says that the individual has the right to information and the opportunity to participate in processes that ensure that the environment can sustain life. That is the core foundational principle of the Escazú Agreement. And what we try to do under that agreement is to ensure, firstly, that those who advocate for environmental conservation, environmental protection, and even improving the environment, that their personal rights are not being infringed upon as a result of doing that. And while it doesn't happen so much in the Caribbean, I can quote a personal experience where I was a target because I was trying to protect the environment. But in Central America and South America, many people are killed because they're advocating for environmental protection. The Escazú Agreement is trying to right those wrongs by coming up with national action plans and roadmaps and creating monitoring mechanisms and reporting these things, creating timelines and storylines so that things that happen in the jungle, in the Amazon, where someone is targeted, will now come to light.
Now, the court also spoke about state actors, that we need to, the member states need to now monitor the work of state actors, private actors. How do you think we can use the Escazú Agreement to see more corporate responsibility?
Well, one of the things about one of the dissenting opinion, I think, is that the state is responsible for whatever happens within its borders. So if a private company does something within the boundaries of the state, then the state has a responsibility with that, because the state would have granted permission, would have had an obligation to monitor, and maybe it did not ensure its laws are being followed. So that is already there. I think the way the Escazú Agreement will do this is through its reporting. By making people aware, the public aware of what is happening, and the extent to which that information could be used to discourage investments by shady characters. I mean,
what about oversight mechanisms?
Yeah, right, you could call it that. For example, if company X is doing an investment in a country, but it's doing harm to the environment, and its funding comes from, let's say, the World Bank. The World Bank needs to know what its funds are being used for, and how it is causing unintentional damage that is inconsistent with the World Bank's own funding principles. So those are the kinds of things that have to be used to try and cushion that.
Wonderful. Now, Dr. Fletcher, let's get back to the court. The court spoke about legal consequences. It was very clear in terms of what we now, and it said that state responsibility, the principles of state responsibility apply where there are breaches, okay? And it spoke to seizing the wrongful act, it spoke to full reparations, restitution, and that sort of thing. Do you think that there is now the need for the establishment of an international register for damages, and perhaps an international mechanism for reparation of climate harms, possibly through the United Nations General Assembly or some other avenue? What do you think about that?
Okay, so the forum that we have for advancements where climate action is concerned is the United Nations Framework Convention on Climate Change, and the meetings that take place under the umbrella of the UNFCCC, be they the subsidiary body meetings in June in Bonn or the COPs wherever they held. What this advisory opinion did was elevate that discussion to the level of the General Assembly and focus the attention of everyone, regardless whether you are a climate activist, whether you follow what's going on in the UNFCCC. Everybody now knows, anybody who follows the UN process now knows about this advisory opinion. It elevated it to the highest court that has jurisdiction over interstate matters, except criminal matters, of course. And it elevated it to the highest decision-making body, which is the UN General Assembly. So I think there is merit in keeping that register within the UNGA, because it now gives the UNGA oversight. So that, yes, there are things that happen at the level of the UNFCCC, the United Nations Framework Convention on Climate Change, that are debated by the 195, 196 countries that are party to the UNFCCC. But at the level of the UNGA, all focus of the General Assembly, everybody's focused there. And if you have now heads of government who attend these UNGA meetings, the General Assembly will meet later on this month in New York. If you now have a requirement that every year there's a reporting that has to take place to look at how countries are being harmed as a result of climate action and what countries are doing to repair that harm, I think that is something that will help the process. So I'm all for elevating this at the level of the UNGA because of the type and the significance and the magnitude of the harm, the gravity of the harm that is being inflicted on countries. Countries now run the risk of disappearing. There are countries that are losing, people who are losing their livelihoods. We talk about climate refugees in a sister island, Dominica. When Tropical Storm Erica hit in 2015, the entire community of Petit Savan had to be relocated. The government basically declared Petit Savan a disaster area, and it's an area where nobody can live anymore. They relocated them, gave them proper houses somewhere else. But that is already happening. So how can you tell me that that is happening and there is no general oversight at the highest possible level to ensure that the people who are being affected, there is some level of recourse for them. And I think the level of recourse being placed in the General Assembly is a good thing.
Wonderful. Now, Mr. Tulsi, so we've heard the advisory opinion first from the ITLOS, the International Tribunal on the Law of the Sea. We then heard from the Inter-American Court of Human Rights, and now we've just heard from the International Court of Justice. We are all preparing now for COP30, which is to take place in Belém in Brazil. Do you think that given those three advisory opinions, and I also believe that at the moment as we speak, the African Court of Human Rights also has a question before it on those obligations as well. So do you think that this is an optimistic time for climate justice?
Yes, but I want to qualify that. Yes.
Okay.
This decision and the other decisions that you mentioned opens the way for litigation. But is that the first action that
we want to
one
take?
would consider?
Okay.
I believe that as much intellectual energy that was put into presenting this case to the International Court of Justice should be put into now deciding what do we do with it.
Yes.
And let it not be a piecemeal approach. If countries feel that by agreeing to a certain text moving forward from this decision, we are likely to face litigation, are they likely to be more to compromise and to reach consensus moving forward on important questions?
I see.
Can the opinion instead be used as a negotiating tool to argue that, look, it's better you fund mitigation and adaptation rather than go the other route that could take us into litigation and those types. I'm using that as one example of what I mean when I say that there now needs to be consensus on how to use this decision to reach the ultimate goal of climate mitigation and adaptation. That's the optimism that I see, that all of these decisions open the way for consensus on the way forward.
Wonderful. So that segues into what do you think, before what do you think are the next steps that countries should take? So we have the advisory opinion now. What do we do next?
And I think, just following on from what Vishnu said, that's an extremely important point, that the first recourse should not be litigation. But countries now know that if you do not do what you're supposed to do, then litigation is a natural consequence of this. And again, going back to what transpired with the tobacco industry in the United States, where the fear of litigation, the fear of class action suits caused the tobacco companies, the big tobacco companies that prior to that were saying, no, this is a personal choice, you decided to smoke, we're not responsible for this, now started putting things like labels on cigarette packages, stopped advertising to children, and did all of the things that were necessary to reduce the harm of cigarette smoking on individuals. And I think that we have to use it that same way. So it now has to find itself, these advisory opinions, the Tribunal on the Law of the Sea, the Inter-American Court on Human Rights, and the International Court of Justice, they now have to find themselves woven into the fabric of the negotiations within the architecture of the United Nations Framework Convention on Climate Change and the Paris Agreement. So that has to be something, as I said, that is as important to us in the negotiations as the science is, because we now have two things. We have the science and we have the law that says that, look, this science, if you do not act according to the science, there are consequences. So that's the first part. That will take some doing, because in 2016, the year after we had the Paris Agreement, there was a special report of the IPCC on 1.5, and it was difficult to get the COP to agree to enshrine that special report in the decision of the Conference of the Parties. So there will be resistance, there will be challenges, but that's where I think there has to be solidarity. I just came back from Nepal, where I addressed the Hindu Kush Himalaya group, which is a group of countries: Afghanistan, Bhutan, Myanmar, Nepal, Pakistan, China, India. And their issues are very similar. They're highland countries, but they're being impacted by climate change. They're known as the third pole. So they have the most ice after the North and the South Pole. But they're also seeing migration. They're also seeing water insecurity. So then there has to be a solidarity among SIDS, but SIDS with highland countries that are being impacted, SIDS in African countries, SIDS in countries in Latin America, that are all feeling that impact of climate change, so that we can have this united force that will say that, look, we must, this slow pace of action within the UNFCCC, whilst all the climate impacts are exploding around us, this can't hold anymore. We must see action within the negotiations that match the urgency of the climate actions we see around us. And if we don't, then we have the litigation that will fall on.
We're due for a break, so when we come back, we will continue our conversation in terms of the next steps. So you are listening to a conversation on the International Court of Justice advisory opinion as regards climate change, the member states' obligations regarding climate change.
Quality information is needed to make the decisions that will ensure St. Lucia's natural resources are used wisely and sustainably for generations to come.
Without information, people are likely to make the wrong decisions, and people are not likely to know what is happening around them and how they could protect themselves.
So welcome back, viewers. We want to say our time is up, so we have got to wrap up very quickly, and just thank you very much you for tuning in to our program. I want to thank my guest, Dr. James Fletcher, our CARICOM climate envoy, and Mr. Tulsi, elected representative of the public. And we look forward to seeing, the next steps that we are going to take towards ensuring that those advisory opinions become a reality, that they help us not only at the state level, but also at the civil society level. So I want to thank all of you, the Government Information Service and the NTN crew, Mrs. Bissett Joseph and her team, for giving us this platform to discuss this very, very important topic. And so we say goodbye and ask you to continue with the programming today. So have a good day. I am Kate Wilson. Goodbye.